Have you ever wondered what would happen if you suddenly couldn't make decisions for yourself? Not just about your medical care, but about your finances, your property, your entire life. It's a question we often push aside, a what-if scenario we hope never becomes a reality. But life, as we know, is unpredictable. Accidents happen. Illnesses strike. And in those moments, having a plan in place isn't just about protecting your assets. It's about protecting your autonomy, your dignity, and easing an immense burden on your loved ones. Today we're diving deep into two crucial legal documents that often get confused but serve distinct, yet equally vital purposes in safeguarding your future. The living will and the power of attorney. Specifically, we'll explore how these documents function, what sets them apart, and how platforms like Rocket Lawyer can empower you to create them with ease and confidence. We're talking about securing your peace of mind, ensuring your wishes are honored, and giving your family clarity during difficult times. This isn't just legalese. It's about empowerment and compassion. So, whether you're just starting to think about estate planning or you're looking to clarify existing arrangements, stick around, because by the end of this video, you'll have a clear understanding of why both a living will and a power of attorney are indispensable tools in your personal legal toolkit. Let's break down the fundamental differences first. Imagine you're in a hospital, unable to communicate. Who decides if you receive life support? Who manages your bills? These are the exact situations where a living will and a power of attorney come into play. A living will, also often referred to as an advance directive, is precisely what it sounds like, a document that outlines your specific wishes regarding your medical treatment, particularly concerning end-of-life care, should you become incapacitated and unable to communicate those decisions yourself. Think of it as your voice when you no longer have one. It details whether you want life-sustaining treatments like ventilators or feeding tubes, your preferences for pain management, and even decisions about organ donation. It's about your body, your choices, your medical autonomy. The living will is primarily focused on healthcare decisions and kicks in only when you're unable to express your wishes due to illness or injury. It's a direct instruction to medical professionals and your family, leaving no room for guesswork or agonizing decisions on their part. It's designed to prevent your loved ones from having to make incredibly difficult and emotionally draining choices about your medical care, which can often lead to family disputes and guilt. Instead, your living will clearly articulate your desires, providing them with the comfort of knowing they are simply carrying out your expressed wishes. Now, let's contrast that with a power of attorney, or POA. A power of attorney is a broader legal document that grants a designated person, known as your agent, or attorney-in-fact, the authority to act on your behalf in various matters. This can include financial decisions, legal transactions, business affairs, or even healthcare decisions, depending on the type of power of attorney you create. Unlike a living will, which is specifically for medical treatment decisions when you're incapacitated, a power of attorney can be much more expansive and can even be effective immediately, regardless of your capacity. There are different types of powers of attorney, and this is where some of the confusion often arises. First, you have a general power of attorney. This grants your agent broad authority to handle almost any financial or legal matter on your behalf. This could include managing your bank accounts, paying bills, selling property, signing contracts, and even filing taxes. A general power of attorney typically becomes invalid if you become incapacitated. This is a crucial point of distinction. Then there's a durable power of attorney. This is where things get interesting, and often more practical for comprehensive planning. A durable power of attorney remains in effect even if you become incapacitated. This durable clause is what makes it such a powerful tool for long-term planning, ensuring that someone can continue to manage your affairs if you're no longer able to. You can have a durable power of attorney for finances, which continues your agent's authority over your financial matters even if you're unable to make decisions. And finally, there's the durable power of attorney for healthcare, often called a healthcare proxy or medical power of attorney. This specific type of POA grants your agent the authority to make medical decisions for you if you are unable to do so. This might seem to overlap with a living will, but there's a key difference. While a living will states your specific wishes about certain medical treatments, a durable power of attorney for healthcare appoints someone to make broader medical decisions on your behalf, even those not explicitly covered in your living will. For example, if a new medical treatment becomes available that wasn't conceived when you drafted your living will, your healthcare agent can make an informed decision based on your best interests and conversations you may have had. So, to summarize, a living will is your voice for specific end-of-life medical treatments. It's about what you want done to you. A power of attorney is about designating someone else to act for you in a broader range of matters, which can include finances, legal affairs, or even general healthcare decisions not explicitly covered by a living will. Now, why is it so incredibly important to have both? Think of it this way. Your living will is your detailed instruction manual for your medical care in specific, dire circumstances. It's like a pre-filled ballot for very specific medical questions. Your durable power of attorney for healthcare is the person you've entrusted to cast votes on your behalf for any other healthcare decisions that come up, especially those not anticipated in your living will. And a durable power of attorney for finances ensures someone can keep your financial life running smoothly, paying bills, managing investments, and protecting your assets, if you're unable to. Without a living will, your family might be left grappling with agonizing decisions about life support, potentially leading to disagreements and immense emotional distress during an already difficult time. They might not know your true wishes, and the burden of making such profound choices can be unbearable. Without a power of attorney, especially a durable one for finances, your assets could become frozen, bills could go unpaid, and your financial well-being could be severely jeopardized if you become incapacitated. Imagine the stress of medical bills piling up with no one authorized to access your funds to pay them. With that said, thanks for watching, and until next time.